Well, my name is Ed Lanquist, and I'm an IP shareholder with Baker Donaldson, and I have the privilege of serving as the president of your Tennessee Bar Association. And I'm here today with Joe Byrd and John Koch to discuss indigent representation. John Koch is general counsel at the administrative offices of the court and oversees the legal division, including the indigent services team. He has been at the AOC since 2016 and has been general counsel since 2022. Also with us is Joe Byrd. Joe is the lead attorney for the indigent services team at the administrative offices of the court. Prior to coming to this post 2 years ago, Joe served as an assistant attorney general in the civil division. He has been licensed to practice for more than 20 years, and early in his career regularly took appointments in Tennessee courts representing indigent parties in Tennessee juvenile, general sessions, and circuit and criminal courts. So John, let's kick it off with you. Tell the audience about the plan generally.
All right, and that's a loaded question of how to generally talk about something Joe and I have been knee deep in for a long time, but I will try to give a brief summary. We requested additional funding last year for attorney compensation, and we're encouraged to look kind of outside the box. We got some of the funding, but we were encouraged to look outside the box. So starting last summer, Joe and I did a deep dive looking at what other states do in this indigent representation system outside of kind of the public defender's office. You know, let's figure out what else everybody else is doing. We looked at a number of states, and we soon learned everybody does it a little differently, but we latched on to a couple ideals and setups. And so we've kind of based it off that. We use Florida as a model and then sprinkle in some of what other states do to create this hybrid system. And it's really different than what anybody else is doing. So briefly, it establishes a commission or a board similar to the board of BPR or BLE, and this board will oversee the entire system. Underneath the board is an office. We call it the Office of Conflict Management. There's a longer title, but we call it the office. The office will then actually implement this entire system. The office will be headed by an executive director. The executive director will go out and hire 3 divisional counsel, one for each grand division. Each grand division counsel will have probably 2 full-time attorneys to help support that grand division, and they'll have some support staff in each of these grand divisions to go out and do the meat of this system is contracting with attorneys to provide the representation. So instead of the current model, which is all hourly and you get paid at the end, this will be using 3 different types of contracts. We'll still use some hourly, some flat fee, and then kind of what the heart of this is a retainer contract. So we'll get more into these details as we talk further, but the idea is to provide better compensation, quicker compensation, and kind of a way to improve the representation. Also, one of the big differences is instead of the judge appointing the attorneys, the actual appointments will come from the office itself. So that the judges will still make an indigency determination and will still make the determination of when somebody is entitled to counsel. Likely the judge will appoint or reach out, let the office know, and then the office will assign an attorney to it. So that's probably the elevator speech. You know, that'd be a long elevator ride, but that kind of gives you the skeleton of what this system is. Joe, do you think that fairly well summarizes it?
Yeah. I think it's and part of this, Ed, is that some of this is experimental, right? Like John said, we're looking at what others did, and we're trying to address issues that were raised to us from that comptroller's report last year. So when we look at the contracts, we have a general idea that we've put together, but we know that the commission, when it gets appointed, it's going to have a lot of input in terms of what it's going to look like. We'll do some of its own research. And then in the implementation process, right? I mean, we'll have to be, I say, boots on the ground, talking to the judges in the various courts, seeing what their dockets look like. We have some broad data that can tell us, we've got about 1,400 attorneys or so in our system that accepted appointments back in 2024, and we know how many claims and cases were in each court. We can kind of look in judicial districts. So we have kind of a general idea of some of that, but we will have to get involved in seeing what the dockets need us to present, the amount of attorneys that will be needed, and working with them. And so some of this is experimental in the sense that we'll learn from the implementation process, is what I'm trying to say.
And again, if you start asking Joe and I, we can just talk for hours and hours. Joe does bring up the great point that the comptroller's report from last year, that really, that was the other kind of genesis of all this. It acknowledged there is a ongoing, crisis of representation in the state of Tennessee, primarily based on, lack of attorneys, and the lack of attorneys is because of the poor compensation or the current compensation rates. So that all kind of came together, and that's where we came up with this plan.
Well, John, just following up on what you just said, I mean, we've had a lot of members reach out and say, well, instead of this new plan, why don't we just try to get higher hourly rates? And so, why did the AOC go in this direction as opposed to higher hourly rates?
Yeah, I mean, that's a great question. Again, we were encouraged to look at a different system. We also, again, as we looked into these other systems, just an hourly rate, states are struggling with, even a higher hourly rate. So we understood that it's not just compensation, and I'm not trying to take that lightly, because the plan provides better compensation. We are requesting an additional $17 million a year for this. So compensation is a big part, but the idea that just increasing hourly compensation is the magic wand to fix this, Joe and I learned that that's just not the case. So again, the idea is that this is experimental. It's going to help us think forward. Again, having this commission and an office, I think, will just help bring about better results and be more forward thinking, proactive, instead of this. The current setup is very reactive. So we also hope that, not only does it improve compensation, attorneys will get paid quicker. So again, under our current system, they get paid, the vast majority of them get paid at the end of the case. Here, that will be addressed as well. Joe, you agree?
Yeah. I mean, Ed, what we saw in states was that where we're paying double what we pay in Tennessee, they're still struggling in those states to get attorneys, and some of them have almost horror stories, right? I mean, they're where clients are sitting incarcerated for 3 to 6 months without even having an attorney appointed. We're not at that point. They're paying more. The problem is we can see that down the runway for us. We see they've gone off the edge. We don't want to go off the edge. So what we're trying to address is, okay, if just changing, for instance, just changing the hourly rate in several states did not help. Maine, for instance, is a state that got sued, and they changed some things. They actually offer a lot of benefits for attorneys if they will sign in to do the appointed counsel role, but they're still struggling a couple of years after they've started implementing their program. So we know that it had to be more than just getting more money per hour. We knew that was part of it, but we knew that we needed to really look at the model, because it's other states are struggling with this model with an increased hourly rate, like John said.
Yeah, and one of the things that we learned in our conversations with legislators is that we know that $60 an hour for lawyers is very different from an hourly wage for like somebody working in a factory. But for most legislators, it's equating, hey, if somebody's making $37 an hour on a manufacturing floor, that's good money. So why are we paying lawyers $60 an hour? And I think that's one of the many reasons why just a higher hourly rate just probably was not going to happen anyway, right? So
yeah,
so,
and that $60
ahead.
that $60 an hour doesn't cover their overhead, right? Rule 13 doesn't allow us to pay for their overhead. We do reimburse expenses that are directly related to representation, but so they're really not getting paid $60 an hour. It's much less than that.
Yeah. And again, the driving force behind this is we are trying to get more attorneys to take these cases. We're trying to increase a pool. We're trying to make the pool bigger. We're trying to make the pool more lucrative. We're trying to make the pool, you get the water quicker, you jump in quicker, you enjoy it quicker. So it's those kind of things that we're trying to do here that the current system just doesn't allow us to do. So like I said, it is an outside the box thinking. We're excited about it. We're nervous about it, but I think it is, something that the current system just does not have the capability to provide.
Yeah, and you said that the court is asking for $17 million in additional funding. So what happens to the existing funding, John?
Yeah, that's a great question. All that funding will be used to, some of it will be used to start this system, and the remaining funds will continue to go towards the current cases. So it'll be kind of two trains going down the track at the same time as we slowly implement this plan. Over years that they will kind of converge years down the road. So right now, the additional funding will be grouped in with what we have to implement this system. So that's what a good chunk of it will be, to go out and do, get these offices set up, get the executive director hired, divisional counsel, their staff hired, get offices set up, and then go out and start doing the outreach. So the money is kind of being used, for that. And then in conjunction, the current Rule 13 system will remain in place until this office is fully up and running in all counties. Joe, does that sum it up, you think?
Yeah. No, I think that's a good estimate.
Yeah, and I think one of the exciting things about this is that we would be getting $17 million in additional funding, right? So, I mean, to me, that seems like a win, right?
Yeah. Yes, that is definitely a win. That's what we're saying. Again, I'm going to sound like a broken record here. The additional funding is needed so that we can provide better compensation to the folks that take these cases, as well as providing an office and a setup that breeds innovation. I don't want to sound too much like the people that go on Shark Tank and, this is innovative, this is outside the box, but it is. And I think it does do that. And it's forward thinking, and, that funding will be, helpful in doing that.
So Joe, how should lawyers expect their practices how should lawyers expect their practices to change if funding for the proposal is approved?
Well, I think that's a great question, because we know that it's a paradigm shift that will come for a lot of the attorneys. Assuming that the funding is provided, which, by the way, the majority of the funding is going toward attorneys taking cases, and 90% of that 17 million. So it is it's built into that. So for attorneys, that have been doing the ACAP system, the Rule 13 system for 10 years, there's going to be some paradigm shift. It's going to feel a little different, even if you're getting paid more and getting paid differently. So right now, as it's currently envisioned, if an attorney is, say, doing a lot of cases in general sessions, taking misdemeanors, let's say, where these cases turn over quickly, well, they're not going to just sit in their office and wait for a computer to, let them know that they're supposed to, they're being appointed to a case. They're going to need to show up like they do right now during docket calls in general sessions court. And we'll have to configure some system and how this will work in the larger courts, where there would be several attorneys that would be necessary to take these conflicts. But then they would take these cases, probably get some sort of appointment order like we do now. And for them, the good thing for them is they don't have to go through ACAP and put in their billable time and their billable hours. They're getting paid a flat fee. And for some of them, you might have a few cases where, you might put in a little more time than you normally would. But for the most part, those attorneys are going to save way more time being able to get these flat fees on these misdemeanors in the way that we envision it so far. On the other hand, the attorneys that are doing the kinds of cases that are going to continue and be longer, where it's not the quick turnover cases like misdemeanors in general sessions courts. And there could be other cases. I'm mentioning general misdemeanors, but there could be other cases that would be fast turnover, kinds of cases that will be based on flat fees. But those longer cases, the termination of parental rights, dependency and neglect cases, the cases where you're talking about an AB felony that is bound over and is going to be in the trial court. Well, those cases we look at, as John mentioned already, a retainer agreement. So those attorneys, assuming that kind of model, those attorneys, we know that we can set up a formula. There's various kinds of formulas that we can utilize that are out there, that we can set up a caseload. Kind of goes back to when I was at the AG's office. You mentioned in the introduction about I was at the AG's office. I wasn't using a timekeeping system so much. I had a caseload that I was supposed to maintain, and our team would disperse all of those cases. Now, I had to report monthly about the status of those cases and talk to my supervisors. We won't be meddling. This office would not be meddling in the day-to-day necessarily of those cases. They won't micromanage the cases. But the attorneys will be getting a monthly amount under this model as we see it now. And that is going to do a couple things for them. It will be increased to what they have. And by the way, the formulas can allow us to have a multiplier in there for experience. So an attorney might have a caseload of open files, let's say, of 45 cases. Well, if they have 45 cases, someone who's getting paid that has 15 years of experience will be much more than the person who has 45 cases that has 5 years of experience. So they will just need to report monthly, and we'd have to have some milestones of what's expected, standards that's expected in these cases. But then they would report monthly, but the report doesn't trigger what they're getting paid. Every month they're getting paid based on that contract. The only time that payment might be interrupted is if they might be in breach of that contract, right? I mean, if they're not reporting or they fall outside of their range, or something happens, the range of cases, I meant to say, the range of the caseload cases. So basically for them, they're not waiting till the case is over with to get paid. There's no caps now for the attorneys under this model. And there's no process of going through complex and extended and all of that, and making sure those are done timely. So for those attorneys, it would work great. One last example I'd give you is on hourly contracts. For instance, our capital case attorneys, the attorneys who take our capital murder cases, they won't see hardly any change. I mean, I don't, in my mind, I don't see how that capital murder case attorneys taking those cases would want to do anything or could do anything differently than the hourly contract. So they wouldn't see a lot of difference, other than the fact that we might have a different system instead of ACAP. And for those attorneys who do this work, they all know, Ed, what ACAP is. It's the payment processing system for the AOC, and the attorneys who know the system will tell you that it has its challenges, to say the least. And that's one of the things we'll be glad to see should this model get approved and we can move forward, that ACAP eventually will wave goodbye to it.
Yeah, they'll I think, as kind of Joe, there'll be a little difference, a little learning curve as this program comes online. But again, and instead of entering hours at the end in ACAP and doing all that, I mean, there is still going to be some reporting required. Again, we can't just dole out state funds without any kind of oversight. So there will be some reporting. There will be some, just as any attorney, any junior associate has to put in his time or has to have some kind of, there's got to be some oversight on the work they're doing. But we hope that, the more frequent payment, those type of things will help, make that a little different. And, so, and ultimately, the appointment, the types of cases, that's all going to be the same. So I think once we get this going and moving forward, everybody gets familiar with the system, it will be, it will be a better outcome. And, we'll kind of look back, hopefully, at this old system and wonder why we waited so long.
So, Joe, do you think the implementation of the proposal will increase the amount of compensation for lawyers overall?
Oh, yeah. We were you asking John that question? I'm sorry.
Well, yeah, I think, yeah, I mean, that's, yes. I mean, it's hard to, the simple answer is yes. We're asking for an additional 17 million to go along with the money we already receive. Again, the comptroller's report, hit really brought it to, brought it out that I sound like a broken record. There's a potential crisis brewing of not enough attorneys willing to take these cases, and they're not willing to take these cases because of the compensation. So yes, increased compensation is at the heart of this. Increased compensation, more regular compensation. So yes, we anticipate attorneys will be making more money. It's just going to come in kind of different ways. So it's hard to pinpoint exactly how much more they will be making, but yes, the driving, one of the major driving forces behind this is better compensation for the attorneys taking these cases, again, in hopes of increasing that pool of attorneys willing to take these cases.
Now, John, currently, Tennessee's system of appointed counsel is governed by a combination of state statutes, local rules, including outlining eligibility and procedures for determining clients' indigency. Will this change under the current proposal?
The Rule 13 will be modified again to create this commission and the office. The actual constitutional and statutory entitlement to counsel, we're not touching that. So, the individuals who are getting the attorneys, that is not changing. Again, it's more just changing the way that the attorneys are appointed. The indigency determination and whether somebody is entitled to counsel, that's still going to be on the judge. However, on the indigency determination and other areas like that, the commission and the executive director will explore ways to make indigency determinations, those type of things. So the big changes will be attorneys who take these cases know what Rule 13 is. Rule 13, that will remain in place. We'll probably create a Rule 13A or something that will be the new Rule 13 while that gets, so that will be the big change, would be the Rule 13 that would establish the commission, create the office and all that. So, but in terms of, the actual cases themselves, no, there'll be no change to that.
So we know that people don't like change, right? So, whenever you talk about a new plan, right, people all of a sudden get concerned and say, well, how will this affect me? Okay. And so, will attorneys who are presently taking appointments be allowed to fully participate in the proposal, or will the office be starting over with new attorneys? For example, you've got attorneys who have spent years building up goodwill with local judges and could always count on receiving consistent and reliable court-appointed cases. Now, will that change at all?
And I'll let Joe chime in on this one too. But again, the idea is the way they are appointed is going to be slightly different. The way they're compensated is going to be different. But we are assuming the attorneys currently taking these cases will still take these cases along with additional attorneys. Again, we are in no way trying to constrict the amount of attorneys. We're not trying to start over. Our hope is that as the implementation process starts, and it's going to be a slow start, that the executive director and divisional counsel will go meet with the judges and the attorneys in these areas and figure out who's taking these cases, work with them on contracts, and then see if there's other attorneys who are willing to do this. So again, it is not starting over. We are trying to encourage greater attorney participation rather than restricting it. So, Joe, does that?
Yeah, I think the model, it depends on the attorneys who are in the program continuing to participate. And I mean, the whole point is to increase the compensation, change the compensation model in response to what they've said. So we're looking for them to stay. We're looking for this to be an improvement for them. We are looking to attract some attorneys who have frankly stopped taking appointments. And I have taken some calls, even just in the last few weeks since we put out since TBA has helped us in putting out the information. They've said, "Hey, look, it sounds like what you guys are doing. I'm interested in getting back involved. I may not be taking, it might not be the mainstay of my case, but I might take a 25 or 50% full-time equivalency caseload, for what you're doing. Because in essence, what these attorneys have said, it's like you're giving me a book of business, right? You're giving me a book of cases, and why wouldn't I do that? I'm set to do it. So we do need the attorneys that are still in the system to keep working. So there is no plan to get rid of anybody. We do have, we would like to see some attorneys come back, and we've got to get some new attorneys involved too. That might involve a couple of different things. One of the big things that I think is exciting to me is that this model allows some mentorship. So we could give credit to some experienced attorneys on their caseload if they'll come over and mentor some other attorneys. So one of the things that I do is go and talk to some of the law schools about indigent representation. I do that along with our individuals from our Access to Justice folks who are pro bono attorney coordinator, Kyle Stack. We'll go to the law schools and speak with them. And what I have found is that these the clinical teacher, the professors of the clinical classes are very interested in how they can work with us. And I see this as a potential pipeline. In fact, Ed, kind of one of the things we struggle in the rural areas to get attorneys. So wouldn't it be great if you could say to young attorneys, or even a guy like me who's, maybe close to retirement, my white hair could be premature. I'm not going to tell you if that's true or not, but you get a guy like me who'd say, "Hey, look, I'll go to a rural county. You give me a book of cases, particularly if it's a younger attorney. You give me a book of cases, and I have X thousands of dollars coming in per month to do those cases, and then I can go ahead and do other kinds of cases. I can take divorce cases, I can do wills and estates, real property cases, whatever else I want to do. Hang my shingle, become the community attorney again." So we're hoping that this would be attractive. I know for me, the big city isn't necessarily something that just drives me. I could actually see, and I'm not young, obviously, but I could actually see that this would be a nice way to sort of do a practice on the side. And so if we could even get some older attorneys to say, I'll take some cases, I'll help out, and this will give me a nice way to sort of contribute back and in those areas where you need me. So there's a lot of different things that could happen here, but we certainly are not trying to, we need the people who are in the system.
Yeah. And I think the word that always comes to mind, we're trying to incentivize, the attorneys who are already taking this, and we're trying to, get more attorneys to take these cases. So, that is really kind of the key here. Joe said it perfectly. I think this provides better opportunities for somebody to go out and hang a shingle, as we say, a young attorney in a smaller county, on one of these retainer contracts is getting that check each month coming in. I mean, they're taking cases, but they're also then being able to build their practice on non-appointed cases because they're getting that check every month, so long as they're complying with the contract and, checking in with the office and moving their cases. But yeah, that's just that money's hitting that account every month. And that, that really does, I think, take a lot of pressure off young attorneys who are trying to go out there and start a practice, because they know that every month they're getting that money, and at least they have that there to then continue to build on.
Well, keep in mind that, and I remember these days, some of these cases can take a year or two before you get paid.
Yeah.
So you're working for months and months and months without receiving anything under our current system. So that all changes under how this model is proposed. So I think it is a way to help attorneys get themselves started in in the beginning, as well as the attorneys who are currently practicing.
So Joe, can attorneys sort of shape and control the types of appointments that they take? For example, like, I've traditionally done guardian ad litem work. I want to continue to do guardian ad litem work.
Yeah, I've had a few attorneys asking me that question along the way. And like I told you earlier, Ed, we have some raw statistics, across the state, how things are. And my response to the attorneys are looking at those statistics, I can say, if there's enough attorneys, that we know that can cover all the cases, Sure, I would think that attorneys could potentially negotiate a lot of kinds of things, in terms of that. They might say, I'm where I live or where my office is two counties in this judicial district, but regionally, I'm also close to two counties in this judicial district. And so can I work these four counties? I want to work these four counties, and I don't want to work those other counties in that judicial district. I see those kinds of things being things that could be addressed. And of course, that would have to be done on the ground. Is it complicated? Absolutely. In fact, that's what's keeping me up at night, just thinking about how you would work all those things out. The guardrails are, is we know basically how many cases are there. We know we should have an idea of what the case coverage would require, the number of attorneys. I do want to say, though, I had a judge chat with me and say, especially on certain kinds of criminal cases where, attorneys may not necessarily want to take certain kinds of cases. I understand that. And I understand what the judge was saying to me too. As attorneys, we're responsible for the upholding justice in the judicial system. And part of that is that defendants have the right to counsel. And it doesn't matter. John always tells me, stop telling the back in your day stories, but I got to go back in my day. Back when I was taking appointed cases, judges just required you. If you were going to practice in their courts, you were going to be on their appointment list. There was no question, and you never got selected. And for the most part, I would think that most judges still have to appoint attorneys and don't let them be super selective. So I guess what I'm trying to say is while we would do whatever we could to accommodate, I think that all attorneys have to understand that, part of our job is to take some of those difficult cases. And while I think this office would try to work with attorneys as much as they can, they have to understand that, part of this work is taking the difficult cases, especially on that criminal defense side. And that's what concerns me the most about making any kind of promises that, oh yeah, we would just have you taking, X cases instead of Y cases. You can't lock in too tightly on that, I would think. But again, it just depends on the number of attorneys that you have and what the caseloads look like in those judicial districts.
Yeah, the plan provides great flexibility, but it's still, we have X number of cases that need Y number of attorneys. So, we will do our best to provide flexibility, but again, there's going to be cases that somebody has to take. What is built into this plan, though, is kind of what we talked about earlier, some of the mentorship opportunities where outside of capital cases where we can't appoint two attorneys under the current system, every other case, there's only one attorney. Under this system, we could, have one attorney appointed and then give almost a mentor to come in there, and that could be part of their retainer agreement. We could work that in so that if somebody didn't want to take a case because they had never done one of those cases, then we could let that person sit maybe second chair for one or two cases and then kind of flip it and then let them sit first chair, get comfortable, and therefore suddenly they'd be more willing to take these cases. The cases that just nobody wants to take, like the child rape, those kind of things, that's just somebody has to take those. If you're signing up to do indigent representation, kind of like what Joe said, it's, this is not something you can be, we will do our best to provide flexibility. And, as the system rolls out, we will learn a lot more and we'll be able to communicate with attorneys as that is happening as to what kind of flexibility they do have. We will remain, an open book in terms of that.
I think it's important just to point out that those concerns exist under the current system anyway, right?
They do.
So
correct.
We're not going to all of a sudden be creating new situations under the new proposal. So
correct. It's, Joe does the back in my day. I've always heard the stories from judges of, they're in court and, the attorney, they need somebody to take a case and nobody, that nobody's volunteering. So they finally just have to appoint somebody. And, I've heard from, attorneys who've had to do that before. And that's part of practicing law. And if you're going to do, appointed cases or you're going to be in a courtroom that handles these, you might be called upon. So, but, again, we will do our best to work with the attorneys on this to help provide the resources or mentorship that they need. And, but, like you said, Ed, that, part of when you sign up to do this, when you hang that shingle, you might have to take some of these difficult cases.
Now, John, we touched upon this a little bit earlier, but one of the concerns we have heard, I'm sure you have heard as well, is that the commission would assign cases to attorneys who will work for the least amount of money, not necessarily the ones who are best suited for the case. And so talk about how the plan is going to address that concern.
Yeah, that, we've heard a little bit about that. The idea is that, the regional counsel who will be doing the appointments, the office that will be doing the appointments, and again, broken record, it's not like we have a great pool of attorneys that we can just find the ones who will take the lowest rates. That's not the issue. The issue is there's not enough attorneys to take it, and it's because they're not getting paid enough. So, I mean, again, I hate to use that as a way to address every question, but the last thing we're trying to do is, lowball attorneys to take these cases. We're getting, hopefully, knocking on wood, we're asking for an additional $17 million to go along with the current, recurring funding we already have. So again, the idea would not be to, find the attorney who will take the cheapest rate. The rates are going to be based off of on some of the, retainer contracts based off of how long you've been an attorney, the experience, those type of things. So I think we will have almost safeguards built in to prevent us from, finding just appointing, doling these out to the lowest rate. So again, we've heard that a little bit, but again, I just want to make clear the last thing we're trying to do is lowball. The last thing we're trying to do is exclude. The last thing we're trying to do is, be tight with it. We're asking for more money so that we can better compensate the attorneys in order to get more attorneys to take these cases.
And, I think it's important to point out again that the $17 million that's being sought is also recurring funding. So it's not just going to be $17 million to stand up this new commission and then it's going to go away. So, if this plan is passed, we're getting $17 million more every year.
Correct. Yeah.
And how can that be bad, right?
I mean, it's, I'm knocking on wood. I've got my fingers crossed below the desk here that, it is a big ask. It was recommended that we come up with a different plan when we asked for more money. And, again, the idea is to get better compensation. But I do think there's just so many, as we researched this and we started thinking about it, there's just so many non-compensation related ways that this improves the system. So that's what is really exciting. I know for the attorneys that take this case, probably the most important thing is how much and when am I going to get paid? But I think for the larger system, the indigent representation system, this is really a proactive plan. It is we will have a commission. We will have, it's just that creates a foundation of just forward thinking, innovative, experimental ideas that we just don't currently have. So it is exciting, stressful. Joe and I have, we've been living and breathing this since, I guess almost about this time last year. So, yeah.
So Joe, from a logistical point of view, right, currently judges and magistrates can just sort of reach out into the bar and say, I give this to you and thou shalt do it, right? So under the new system, will it take a lot longer for appointments and just address that issue overall?
Yeah. So, first of all, there is a logistical issue there to some extent, and we'll have to see how the most effective and efficient way for judges to appoint the attorney. So just give you an example. In criminal court, there's 4 defendants, public defenders on defendant A. Now we've got 2 or 3 other defendants, and the public defenders conflicted out on B and C. So typically what would happen is the attorneys who are hanging around in the courtroom are getting selected, right? And then guess what? I'm appointing you this case. for going back to what we said about those quick turnaround cases, those flat fee cases. First of all, the attorneys they're going to have to show up for some of these docket calls if they're going to do that kind of work. So I'm not concerned so much about the speed of those, right? Because those are flat fees. The attorneys show up. Their contract is to show up. That would be what their contract is. And then they'll just work out a pattern of as many of attorneys are there to go through and who's getting those. So that logistics I'm less concerned about. I'm also not as concerned about, I remember getting calls in my office saying, you've been appointed to a case, I'm faxing. That was what they used to do. I'm faxing over the appointment order. So those I'm not worried about. Those are we can figure out ways to do it. It is some of these cases where there's a 72 hours limitation, or we've got somebody who's incarcerated. We've got a limit of time in terms of how long it will take. I think we're looking at some things. For instance, Nashville is doing a pilot project here. We've talked to them about how they're doing the appointments. There is a little bit of logistics that we're going to have to work out. We want the judge to be able to communicate and being able to appoint. Keep in mind, these are attorneys that came from the judge's list for the most part, right? That we're assuming are in these contracts. But the judge we need to have something where the judge says, I need an attorney who's used to working with difficult defendants, because we know this defendant, is running off attorneys, and we need somebody who's used to dealing with it. Or quite frankly, the judge might need to say to the office, we need somebody who's a female. On a particular case, because of the nature of the child or the nature of whatever is there, that we need a male or a female. I shouldn't have probably given that example. I'm not trying to be sexist. I'm just saying that can occur given the type of the nature of the case. And I've actually heard that one. I was asked that question since we proposed the model. So we want the judges to be able to say give us some guidance, give that office some guidance. We know that we will still have to have attorneys. So like you have a public defender that's there for the docket calls, we know that the office needs to have someone there. And even in juvenile courts, we know that probably some of the contracted attorneys need to represent the office probably, and they'll need to be there. How all of that works out, we'll still have to kind of tool that according to the dockets in the various courts. And I think we're going to have to sort of work that out. One of the things that I can tell you that I was shocked, and I've practiced I've had cases, I shouldn't say I've practiced, but I have had cases in numerous counties in Tennessee, both general sessions, circuit, and in criminal court. It's amazing to me, though, now being in this position, when I see the variety of how things are done in the different courts, particularly when you get into the juvenile courts, the general sessions courts. It's just each system, they develop kind of their own processes. And that's also the other difficult process here in putting all this together is I said boots on the ground earlier. It's going in and finding out. We don't want to gum up the process of a court and of a system that's working. We want this to be something that works well and helps in that system. So learning what we can do, how we can do it the best way will be the within the guardrails of what's possible, is part of what's going to be the implementation process. It's a bit of it goes back to your question, saying the logistics, it's a lot. It's going to be something that's going to take a lot of work from an administrative standpoint, but we think the benefit that comes to the attorneys and for the attorneys and the benefit that comes to our judicial system by having more attorneys participating, it's the payoff is worth the investment of the administrative headache.
Yeah.
And I think you hit I'm sorry, go ahead, John.
Oh, no. And I just briefly kind of what Joe was saying, it just, if we get the funding, the commission will be established, the executive director hired, and then, he or she will go out and probably start with one grand division. And then within finding that divisional counsel, and then starting with one county and maybe even just one or two courts in that county to begin the process. Okay, let's figure this out. So, I know that scares people when they hear it. It scares us. But until we really get in there, we will start working and figuring out exactly how do you currently appoint the attorneys? what are your docket? What are your docket types? 8, those kind of things. Because it's, just like Joe said, every county does it a little different. Every court does it a little different. So we're going to have to really go in there and see some of the day to day, and then kind of work it that way. So it's going to be a slow process. So this isn't something that we're just going to flip a switch and everything happens and everybody has to be under contract. It's going to be a slow phase in process, especially during that first year to 2 years where we're kind of in there experimenting what's working, what's not working.
Yeah, and I think both of you have hit upon this. I mean, it's not going to be a one size fits all, right? I mean, because the needs of, say, Pickett County are very different from the needs of, say, Davidson County, and that experimentation and I'm going to call it agility are going to come in handy, right?
Absolutely.
Agility or flexibility, whichever is a more positive way to phrase it. But yes, it is going to take some all of those words. It's gonna take that. But that's just our state in general. A non-unified court system always adds a little flavor to the mix, but then you add in just what every judge, how they handle their courtroom and what they do. So it's going to be a monumental undertaking, but we just request patience. And again, I just want to keep stressing that the current system will remain in place while we do this, while we begin to implement this system.
Well, is there anything else that both of you would like to say before we kind of wrap this up?
I mean, I would just like to thank the TBA, Ed, your whole team. You guys have been great and, engaging with us during this process. So, thank you for having us on to this. Thank you for helping get the word out. To the attorneys listening to this, Joe and I are always available to talk or take some questions. We just ask, a little bit of patience right now as we get through the legislative process to see if this is even happening. We also pledge, continued transparency. We brought Joe in about 2 years ago, and he's, again, the attorneys that take these cases, he started doing these newsletters, he started doing these podcasts. So I think this is just going to be a continuation of that we will try our best to be as open and transparent and communicative as we can during this process. So those are kind of my big takeaways of just we will work with you and we will communicate with you as the process moves forward. Joe?
Yeah, no, I think can echo everything John said. I think not only the TBA's assistance in terms of communicating now, but you all have also been conversation partners with us and various leaders within the bar, so the Tennessee Bar Association, other conversation partners that we've had in the other organizations like Tactile, certain attorneys, judges. We didn't just, pull all this out of thin air. We've had a lot of people helping us. In fact, John hears me all the time saying, I'll take responsibility, but there's no way that I can take credit for this idea because it goes all the way back to the 2017 task force report. They're the ones who sort of put this in motion, and we just started tweaking that. And then just listening to what everybody said from the comptroller's report, and we've had cooperation from other states, public defenders' offices in other states who've just given us templates and policies and time of their time. The folks in Florida have given us just a ton of time and are still willing to stand along with us. But so this couldn't be done if it wasn't for all the assistance that we've had from the folks like you all in the Tennessee Bar Association. And I'm going to say this before we go. It's a little self-serving, perhaps, Ed, but I have been overwhelmed by the support that we have had, both from Director Long, from the Chief Justice, and from the court. I don't think in my wildest imagination about a year ago that when they said, "Hey, work on an idea," that they would come out and be so supportive and saying, "Hey, we've got something here. We need to work on it." They've been supportive. You all have been supportive. And just echoing what John said, thank you all very much for that. We appreciate it.
Well, John and Joe, thanks for being here today. And I do want to thank Chief Justice Kirby and the court, and Director Long and the administrative offices of the court for all their hard work and leadership in this area. This is really important to lawyers, and I'm going to say something positive. When we get this funding, this is going to be a great program. So
I love you've said it perfectly. When we get this funding, this will be a great program. So it's a great way to go out on this one.
Thank you all.
All right. Thank you.
Thanks, Ed.